Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, welcome to our Curious Amalgam from the American Bar Association section of Antitrust Law. My name's John Roberti. Today's topic is a unique case. The EU takes on Amazon. Today what we're going to talk about is the European Commission's competition law investigation into Amazon. As many may know, the European Commission is the EU's civil service. It's based in Brussels, and among other things, it's the lead enforcer for the EU in relation to competition and antitrust law. And there is a very interesting investigation of Amazon that we'd like to talk about today. My co-host is Matthew Hall. Matthew is an EU and UK competition law at the McGuireWoods law firm, and he's based in London. Before moving to London, he lived and worked in Brussels, which is the EU's effective capital city, and he was there nearly 18 years. Hi, Matthew.
Hi, John.
So, Matthew, tell us what we're doing today.
Well, most listeners will, of course, have used Amazon.com or an equivalent at some point. It has a dual role as an online distributor and as a marketplace. So, as a marketplace, it's a platform for third parties to sell products directly to their customers. And as we know, as a distributor, it buys in goods from third parties and resells those to its customers.
So Matthew,
and it also sells its own brand. Yeah.
I'm sorry, Matthew. So, does having that dual role create any special competition issues?
Well, that's what we're going to discuss today, and that seems to be what the European Commission is looking at now. So at a broad level, it obtains information from these third-party sellers and their customers, and it may need that information for its normal business purposes, and it may use it in an otherwise. So that's what the Commission is looking at when it opened its formal investigation on 17 July 2019.
Let's bring in our guests. Matthew, who are our guests today?
Today we have Silke Heinz of Heinz and Zagrazek in Cologne, Germany. We have Damian Jaredin of Euclid in Brussels. Silke is a founding partner of her firm, which is a competition and compliance boutique. She was at Cleary Gottlieb for over 15 years before that. As well as being a partner at Euclid, which is also a boutique competition law firm, Damian is a professor of law at Tilburg University in the Netherlands, and a visiting professor at UCL in London, University College. And he is also a big law alumni, or an escapee, if you like. He was previously at Covington and Burling.
Matthew, these are great guests. Silke, welcome to the program.
Hello, everyone.
And Damien, thanks for being here.
Hi.
Yeah, thank you. Welcome, and thanks very much for joining us today. So, Silke, we talked about this briefly, but could you just take us through very briefly, please, the big picture? What are the competition law concerns now that the European Commission is worried about as relates to big tech?
So the general concern is to keep tech and digital markets open for competition. That means preventing foreclosure and to ensure that dominant compete on the merits. And you can see that this sort of cuts across the various enforcement areas.
Silke, when you say foreclosure, what do you mean?
Well, foreclosure means, basically foreclosing competitors to put competitive pressure on the players in the same market. That can be an abuse of dominance. So there the EU has focused on exclusionary conduct, for example, exclusivity arrangements or bundling and tying practices. That was Google Android. You also have leveraging a dominant platform position into adjacent markets. There in particular, a concern has been related to so-called self-preferencing, so of the platform's own product or services with exclusionary effects on rivals, and that was the Google Shopping case.
And when we talk about abuse of dominance, in the U.S., is that what we call monopolization?
I think it's more than monopolization, because monopolization is actually turning a market into a monopoly. That is not an issue here, but it's really an issue once you have a monopoly or a dominant position, you are under special obligation to not to abuse it.
And Damian, we're not talking about merger cases really today, but there have been some data issues concerning big tech in mergers, haven't there, as well?
Yes, that's true. At the moment, the Commission and various national competition authorities are very focused on the use of data by platforms. And this is a concern that came out also in mergers, such as, for example, Microsoft LinkedIn or Facebook WhatsApp. Now, it's never been something that led to a prohibition or to very strict remedies, but it's definitely in the background. And I think, as you said earlier today, it is certainly one of the major concerns of the Commission, which is, what to do with these platforms holding very significant troves of data.
Yeah, and as you mentioned, Facebook, WhatsApp, I mean, some of these cases, some people think, were maybe incorrectly decided. I guess that's water under the bridge, but those concerns, I think, are leading to some questions about whether these companies should be allowed to make acquisitions at all without much more control. But that's a thing for another day, really.
Mm-hmm. That's correct. And I think that some mergers, for example, such as Facebook WhatsApp, which was reviewed by the UK Competition Authority and cleared by the UK Competition Authority, has been seen with hindsight as not very fortunate, and perhaps today regulators would take a different position on these types of transactions.
Yeah, maybe we'll have a podcast on that another day. But looking at the Amazon case, can you take us, Damian, briefly through the timeline of this? And I think it may even have its roots in the European Commission's May 2017 e-commerce inquiry report.
By focusing on the timeline of this investigation, and then I will say something about the e-commerce sector inquiry report. So what do we know about the case? Well, we know that Commissioner Vestager confirmed in September 2018 that the Commission was starting a preliminary investigation on Amazon. Then the Commission did what it usually does, which is to send requests for information to a large number of companies, in particular retailers selling on Amazon, to better understand their relationships with Amazon when they use the platform. Then finally, on the 17th of July, the Commission initiated a formal investigation against Amazon. I should say for our U.S. listeners that it is still early in the investigation. It will take certainly many more months or years for the Commission to investigate the matter before turning to the next phase in the investigation, which is to issue a statement of objection if we get to that point. Now, you're correct also to say that this may have as its source a sector inquiry that the Commission carried out in 2017 and issued a report. And this report already alluded to what could be seen as the core element of the Commission's investigation. And I just quote one sentence, which is very telling. So the report says, marketplace operators sometimes act as an online retailer on their platform in direct competition with third-party resellers, competitively sensitive data provided by third-party sellers to marketplaces or generated on marketplaces in relation to third-party transactions could, absent any safeguards in place, be used in order to boost the retail activities of the marketplace operators at the expense of third-party sellers. So the crux of the matter is that the Commission already at the time, which is 2 years ago, saw as potentially problematic the fact for a platform to compete on its own platform against retailers while being able to use their data, for example, in its pricing activities.
Thanks, Damien. I guess we'll get into the detail in a moment, but Silke, I just wanted to make some slightly controversial comment, but we won't name any names here, but a lot of people say that the European Commission or the EU in general likes to pick on large US tech companies. John's mentioned Google, Apple, maybe even Facebook, across a range of areas. Is there justification for that, or is it really based on pure competition law questions?
Well, I think that there is no real, I know there are conspiracy theories out there that this is really anti-US bias. I don't think that's true. If you look at what we were talking about, these were mainly abuse of dominance proceedings. If you look at other areas of antitrust enforcement, you also have tech companies that are European subject to enforcement cases. But of course, if you look at presumably dominance abuses, you look at powerful and big companies. And of course, US companies are the biggest and the most successful in the tech field. So if an enforcer decides to look at potential abuse of dominance cases, they seem to be the natural target, if you wish. So their success makes them an addressee if they engage in what a regulator could call abusive conduct. So I think there's the simple reason for that. A second reason, you may wonder why Europe has been at the forefront of this enforcement trend, if you wish. You also see now that the US agencies are following. They are also considering or have opened investigations. Why the difference? Well, again, I don't think it's bias. You see, if you follow this bias theory, that could imply that US agencies haven't started earlier simply because these are US companies. And I don't think that is true either. I think it has to do with the difference in test. There are still some slight differences across EU law and US competition law. I won't go into all the details here, but remember that EU law tends to be stricter, and it's not only about pure consumer harm or consumer efficiencies, but it is also about the protection of the competitive process. That sounds esoteric to Americans, I know, but it means that in Europe you still believe that having competition in the market is something positive, and that maybe allow enforcement agencies to engage in this foreclosure theories of harms more easily than in the US.
So, Silke, I have a follow-up question. And what I thought I heard you and Damien saying is that the investigation is about Amazon using data on one side of its business to advantage it in sales on the other side of the business. And I can imagine a company that's not Amazon that sells a product to a distributor and then also competes downstream against that distributor. Does this investigation suggest that using the data from your wholesale side of your business to advantage your retail side of your business, that can be a problem?
I think we may come to that in more detail when we talk about the theories of harm, but I think it does. There are two aspects. One aspect is, of course, it could be due to Amazon's dominant or powerful position. That is, of course, something that is special here. And it also always is an issue of exchange of information amongst competitors, and that is true not only in platform scenarios, but also in other scenarios, of course.
So Damien,
Yes.
how would the exchange of information among competitors apply here?
Well, I think that once again we'll talk about this when we discuss theories of harm. But I think it's important to say also that one of the reasons why the Commission is looking at this case is because there's a need for guidance. Of course, it's an enforcement action, but I think that, given the existence of multiple marketplaces, some bigger than others, there is this question of whether it is okay for a dominant platform to use data, as you say, from rivals in order to compete with them on a downstream market. And I think that's a question that is relevant to many businesses, because many businesses are using platforms to sell their products. And I think this is an opportunity for the Commission to look at that question and come out, possibly with a set of remedies or a decision that will, provide guidance to other companies.
I mean, as you say, there will be theories of harm behind this. We've got the Commission's press release from 17 July 2019. It looks at two main areas, which, John, we've been alluding to here. Could you just take us through what appear to be, and the Commission also refers, interestingly, to potential investigation under both Article 101 of the Treaty of the European Union, i.e. the one which bans anti-competitive agreements, and Article 102, which bans abuse of a dominant position. So what are the two areas that specifically on this case they seem to be looking at, which we've been alluding to so far?
Right. So I think it's quite interesting also to look at what the press release from the Commission doesn't say. It doesn't say that Amazon is dominant on any market. And I think the reason why it mentions 102 and 101 is because it gives it more flexibility. That means that if the Commission has difficulties establishing that Amazon as a dominant position on a given market, then it can still switch back to 101, where you don't need to show dominance. You just need to show that, there's an anti-competitive agreement that is basically there. Now,
that's an interesting point, Damien. If I could just, that's an interesting point. I looked at some evidence that Amazon gave to the UK Parliament, and they seem to be running a similar kind of competition as a click away argument. They mentioned that people can choose to sell on Amazon or elsewhere. There are hundreds upon hundreds of marketplaces. It's not only Amazon and maybe eBay, but it's Alibaba, Wish, Depop, Spock, Otto. Many of those I haven't heard of. But
Otto is German.
Okay. They seem to be, as you say, maybe thinking of running a competition as a click away argument.
Yeah, I think that's right. And what is really interesting when you think about, the dominant position issue is that I think it's going to be one of the two major points in the investigation. I think the first one is market definition and dominance, as I will explain in a second. The second one will be the extent to which, Amazon is really sharing data between Amazon as a marketplace and Amazon as a retailer, right? I mean, is there any sort of Chinese wall? Is it functioning or not? But on dominance, national competition authorities which are looking at Amazon practices are not consistent. For example, the Bundeskartellamt in November 2018 said Amazon holds a dominant position on a possible market for marketplace services for online sales to customers. Then the Italian competition authority said in April, Amazon would unduly exploit its dominant position in the market for e-commerce platform intermediary services. Now, the Luxembourg Competition Council found that Amazon was not dominant in online service platforms, with eBay and Price Minister amongst its competitors. So I think that's going to be a big question. And indeed, I think that Amazon will basically say, look, we're only one amongst many, while the Commission will try to define a market that is sufficiently narrow so that, they can be identified as a dominant player. So that's going to be really quite interesting, going forward.
That's interesting, as you say, and they may, as you say, be using 101. If we look at the press release, there are 2 points. One is they're looking at standard agreements between Amazon and marketplace sellers, so that there's agreements there. But then, Silke, the second thing in the press, the second main heading in the press release is this reference to the quote buy box, which I think I remember. You do a one click and you find you've bought something without really even knowing. That's what seems to happen sometimes. So what do we know about this buy box being the second area of interest that the Commission seems to have?
Yeah, it's really about, the question that the platform can, of course, control the ranking of the participants on the platform. So here, Amazon controls the ranking. The buy box is actually the basket that appears next to the picture of a product that you've searched. And there is a ranking of dealers offering that product or similar products. And the one that makes it into the basket or buy box is, of course, the most likely to be clicked and gets most of the sales. So this is actually based on an algorithm. It's a little bit like in the Google search engine case, where you get to the top of the list. And Amazon controls that algorithm, so it can also control the ranking. There, the concerns can also be, are these really objective criteria that are used? Are they applied in a non-discriminatory way towards dealers and Amazon? And even if they are, one question, of course, is, doesn't Amazon have an intrinsic, and is it really a fair advantage because they know what the algorithm is? And they can specifically target their own products in a way, in terms of pricing, etc., based on all the data they have received on their competitors from the platform to appear in that basket, of course.
So we are starting to run up a little bit on time here. I have one question. Maybe we'll start with you, Silke. Who should be worried about this? What businesses, what people should be taking notice, worried, happy about this investigation?
I think in the end, a lot of companies, it's not only Amazon and the dealers, it's basically, as Damien said, there are many platforms out there. It's not even only in the B2C platform area. You also have similar setups, or at least potential information exchange concerns. If you look at B2B cooperation, B2B platforms, data pooling arrangements, or even, Internet of Things. So there will be more platform-based cooperation amongst competitors in the future. And for all of this decision and, what the real theory of harms and concerns are will be very interesting, I think.
Damien, how about non-platform-based businesses? Should they be taking notice?
Well, I think that I think that generally non-platform-based businesses are less vulnerable to this sort of investigations at the moment. I mean, if you look at basically the docket of the Commission, they've been dealing with Google, they're dealing with Apple, they're dealing with Amazon, and they're also looking at Facebook. So it seems that the Commission at the moment is very focused on digital platforms and what they can do and they cannot do. Now, I think what is important is that, and I think it was already mentioned by Silke, is that we're always looking at these, 4 big companies, but they're there are platforms a little bit everywhere. If you look at online advertising, you've got ad exchanges. If you look at energy trading, you've got, trading platforms for electricity and so on and so forth. So I think it will be really quite interesting to see how the Commission will develop its theory of harm and where this is heading. Now, of course, other companies will see it as a signal that the Commission is willing to use its enforcement powers to go after dominant firms. The fairly strict approach that the Commission has been pursuing for a couple of decades is still very much alive. Now we will have a new commissioner, coming up in the fall. And if this new commissioner is not Mrs. Vestager, who could keep her position, maybe that person will have a different view of the world. But I think generally the platforms and the tech firms will have a very challenging time in the next few years.
Matthew, over to you. Any final questions for our very distinguished guest today?
I think I'll just ask Silke. Do you see any other particular areas, Silke, that the European Commission in the competition field might look at over the next 5 years? There's China. There's, of course, the whole e-commerce distribution more generally. What do you see as the main topic or topics?
Well, I think they will further look into digital platforms and how they develop into entire ecosystems. So, they're really expanding up, down, left, right. So how to deal with these ecosystems will be a big challenge in the future. There will be, as I already mentioned, Internet of Things and blockchain technology. So the industrial revolution in this area is continuing very fast. And one aspect is also whether dominant platforms in the future will have to grant access to their data. That is a very hotly debated topic at the moment. There are no recent cases, but this will also be something to look out for the future.
Okay. One last question. I have one last question for each of you. So, Damien, let's start with you. Can you tell us something surprising or unusual about yourself, or something that people who only know you professionally might not know about you?
Well, a couple of things. I think the first one is that I started as a private practitioner at 38 years old. Before that, I was a law professor, full-time law professor for 15 years. So that means it's never too late. And I think that to have another career before becoming a private practitioner is not a waste of time. I think it gives you, other insights and skills that you can use in private practice. The second thing, a bit different from professional life, is that I'm a watch collector, a vintage watch collector from chronographs from the 1960s and 70s. And so when I have a bit of time, I just enjoy, looking at watches and trading watches.
Silke, how about you? Tell us something surprising or unusual about yourself.
Well, I know myself for quite a long time now, so I don't surprise myself that often any longer. But people tell me they find it surprising that sometimes I do seem to have a sense of humor despite being German. So that seems to be surprising still in this world, talking about cliches. And since Damien mentioned what he did before, and it's never too late, of course, with my last name, Heinz, I still hope it's never too late to be discovered as being part of the big Heinz company group here. So that would be nice too.
And I think that will do it for us today. We will be back next week with the next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.